Touche. We've been asking our local convenience stores, okay, for the last 80 years, and our local bars and our restaurateurs to age verify for 80 years. All right. So, Chris, when we were, maybe not us, but when other mischievous boys would go up to the corner store and try to buy that Playboy, all right, the convenience store would be like, no, Mr. 12-year-old, you cannot have that Playboy. You know, the one that was behind they had to put the opaque little cover on the front of it, and it's in the plastic wrapper. That one, I would never did this. Okay, I never did this, but I've heard. And
my friends did.
Yeah, my friends. It's always Frank. Welcome to episode 102 of the Weekly Docket, a podcast by the Silberman Law Firm, where we talk legal news and practical law. Today is December 26, 2025. I'm Phil Silberman, owner of the firm and your host, and I'm joined by Chris Heald, who is our supervising attorney at the firm. And Chris, today is the day after Christmas. Lesser podcasts are airing reruns or not shooting at all. Not us, Chris. We are here. You actually came festive, which I appreciate. And then I made you take
Isn't
off.
Today Boxing Day? I was worried you were going to ask me what Boxing Day is because I don't actually know.
You don't know what Boxing Day is? So Boxing Day, we weren't going to talk about Boxing Day, but that's a good question. Boxing Day in merry old England, if you were wealthy of the upper classes, you wanted to have a nice Christmas day, right? So you wanted all your servants there. So all your servants were there and they worked in your home on Christmas Day so that you could enjoy your Christmas dinner. And then the very next day, you would allow all your servants the day off. And what you would do is you would put all the great stuff that you had for Christmas in a box. And you would allow allow them to take it to their quarters or take it home with them. And that's hence the term Boxing Day, because all the servants got to take all the good stuff the very next day as leftovers in a box. That's how that worked.
Yeah. So I was today years old when I learned it had nothing to do with pugilism, which is very disappointing.
After the show, you're going to define pugilism for me. But anyway.
Doesn't that mean boxing?
I don't know.
The sport?
Probably it sounds like it.
Yes.
I don't know. There's a Spanish word pegar to hit, maybe that's related to pugilism. You know how that stuff has Latin roots, but Chris correctly defined pugilism for us. And I've learned a new word today. And for that, we are all smarter and we can move on to what is on our docket today. And the first thing we're talking about, legal news, we've got a federal judge blocking a Texas law that was supposed to go into effect first of the year, 2026. And the law was going to restrict kids from downloading apps and going on the App Store. But the Fed judge blocked that. We'll talk about why. And then we'll be answering a legal question. Here it is, the legal question. I'm buying a business. Can I use the money in the business accounts to buy the business? And we'll talk about the answer. And I thought that was obvious, but apparently not. We'll tackle it. And then finally, in our rant and rave section, we'll be talking about how AI, LLM, large language models work, actually, how they really work, and just clearing up some common misconceptions on using some AI for people. So should be a short show today. Let's get it kicked off with our legal news section. Texas Senate Bill 2420 would have gone into effect January 1st, 2026. Chris, we talked about this. It establishes age verification requirements and it mandates parental consent before a minor is allowed to download or make purchases with an app. Chris, you like it, hate it, don't care about it.
I like keeping kids safe. I don't always like government regulation. It's certain apps, right? It's meant to keep kids off social media. Isn't that the overarching goal?
This, I think, is a little different. This was a more nuanced law, but related to several of these laws that have come out of conservative states. What this one was going to do is you can't even get into the App Store, right? So Apple's App Store, Google Play, unless you've age verified. And my initial impression was like, oh, this is a great thing. My 5-year-old can no longer download the Barbie app, and I've got that $4.99 a month charge that I've got to cancel later. I was more concerned about me. I was not about the kids. I was like, this is awesome. No more Barbie app purchases, but a Fed judge shut it down. So that's this law, Chris. So what do you think about that? Are you okay with that?
I do like it. I think most apps have, you got to go through a lot of steps to actually buy stuff because I'm in the same boat. I had the same issue where I saw charges on my credit card for Barbie clothes, not the real Barbies, the Barbies on the
Yeah.
app,
Yeah.
$12 charge for their clothes, which did not go over well in our house. But to not let the kids on there, I guess the issue is then they're just going to learn your password like our kids already have. And once they do that, they're in anyway. So it's
Yeah.
always the user that kind of fails the process.
Yeah, I guess you've got to have the better passcodes and setup and all that. But yeah, I know what you mean by those in-app purchases. I used to call it pixie dust or fairy dust. Like my kids are like, "Oh, Dad, I want $12 for the Fortnite skin or Barbie do dress," and I'm like, "That's not a real thing. That it doesn't exist in the real world. You're paying nothing for. You're paying something for." Something completely made up pixie dust. And then adults went and created Bitcoin. And my kids were like, "Dad, see, I told you." Yeah. So there's that. All right. Here's the judge that did it. U.S. District Judge Robert Pittman, Obama appointee, no surprise, on Tuesday sided with I like this, the law's opponents. So, right. Probably the lobbyist for Meta and Google and all that. And the judge said parts of the law are unconstitutionally vague and exceedingly overbroad. And here's a quote from the judge, Chris. Now, tell me if you agree or disagree. The judge says, the act is akin to a law that would require every bookstore to verify the age of every customer at the door, and for minors require parental consent before the child or teen could enter, and again when they try to purchase a book. Pittman wrote in a 20-page ruling. He wrote that quote. What do you think, Chris? Do you agree with that logic by the judge?
Even if he's right, I don't have a problem with that. Isn't that what bars do? You have to age verify to get in, and you have to age verify to buy a drink. This doesn't sound too onerous that we do.
Touche. We have been asking our local convenience stores, okay, for the last 80 years, and our local bars and our restaurateurs to age verify for 80 years. All right. So, Chris, when we were, maybe not us, but when other mischievous boys would go up to the corner store and try to buy that Playboy, all right, the convenience store would be like, "No, Mr. 12-year-old, you cannot have that Playboy." You know, the one that was behind they had to put the opaque little cover on the front of it, and it's in the plastic wrapper. That one, I would never did this. Okay, I never did this, but I've heard. And
my friends did.
Yeah, my friends. It's always friends. How is this?
And they said, they just say you didn't get it here, and they slide it over and they take your $5 and they say you didn't get it here.
We've been asking convenience stores to do this forever, and all of a sudden the judge is like, "This is a terrible idea." Okay.
Yeah, that's bad logic. If that's what you're hanging your hat on, that's tough. That's a stretch by the judge.
Yeah, that I don't love it. Again, I'm just going to emphasize that judge was an Obama appointee on that. We're just going to call that Obama appointee logic. Well, I don't like it. We'll see what happens with this law. We'll see if it gets appealed up to I don't know where Pittman was. Must have been somewhere in the Fifth Circuit. So we'll see if the Fifth Circuit takes it up, and we'll go from there. All right, that moves on. Look, that brings us to our next section, our legal question section. Can I use the money in the business accounts when I'm buying a business and I'm purchasing? All right, Chris, here's a scenario. And you tell me, I have to figure out how to explain this. And I know you're not really a business guy. You're not a finance guy. So I'm hoping you can empathize with this question. Here's what's going on. We've got a client buying a business, and then let's just say it's the entire LLC or a corporation. It's the entire corporation. It's not an asset purchase. They're buying the LLC. And let's say they're paying $1 million for it, and there's $100,000 in the operating, that they use for business expenses. And the client's, "Hey, I'm buying it from a sole owner, sole shareholder, and I'm going to be the new sole shareholder or sole member of the corporation or LLC. And I'm paying $1 million for it, but hey, I'm a little short on cash. Let me just borrow that. Let me just not borrow. Let me take the $100K in the operating account. Let's just pay $900K for the business. What's the difference?" Chris, what do you say to that?
I think you probably can't use money that's not yours.
Yeah, that's a good inclination, right? Because the idea is it's not really your money yet. So you can't do it. Okay. But practically, what's the difference? We can talk about that in a second. Chris, let me phrase it in a different way. Let's say we represent the seller. Let's just say the seller, period, decides to take the $100,000 out of the operating account the day before closing. I mean, if really we're going to have a problem with it, right?
Yeah, usually, and one step further than that, usually I don't know if it's a look back period or a diligence period, but it's business sales are specifically designed so that doesn't happen. You want to take the business at the value you're purchasing it at.
Yeah.
And if once you take possession and you start running the business and you realize, hey, the assets that were supposed to be here aren't here, we have a problem. We need to square
Yeah.
up some of these numbers.
That's a great way to say it, and I'm glad you said it that way. In accounting or finance lingo, it's basically if I'm paying $1 million for a business, I'm paying for the future cash flows, but there's also a component of book value in that business, and book value is really just assets minus liabilities. And to keep things simple, if it's a services business, and let's say there's no debts, no liabilities, if you've got 100K in an operating account, that's the only asset is $100,000. So the book value of that business is 100 grand. So if you're paying $1 million for the business, part of it was the 100K book value plus the value, really the present value of future income streams. That's how you get your $1 million. So if you rob the coffers 100 grand the day before it closes, I'm going to accuse you of business fraud for just withdrawing the money out of the operating account because you've basically decreased the value for my purchase price. So now your business is only worth 900 grand. So that's the illustration we're working with. Now, Chris, here's what a buyer could do. You could close on the business and then declare a distribution because you're the sole shareholder. Nothing presents you the day after you're the sole shareholder. Declare a distribution, distribute 100K to yourself if you want. Happy to do that for you. As lawyers, we do the legal paperwork and the bookkeeper can do the bookkeeping, no problems. But now all you've done is drain the operating account. And then the next week you've got payroll coming up. So how are now you have no money for operating expenses. So you just did a distribution. Now you're going to have to do a contribution, which your distribution and your contribution, those are equity accounts, Chris. They're offsetting equity accounts. So there's no materiality to that. That was a lot on that question. Like we've explained that.
Yeah, for people like me who aren't accountants, but what we do need to know if we don't understand balance sheets is we have to know that the money has to match. And I think that's what you're getting at is if I'm buying $1 million business, that business needs to be worth $1 million on the date I purchase the business. And if the numbers don't match, we get into accounting nightmares, tax nightmares, and in worst case scenarios, we get into lawsuits where people are fighting. And now we're going back to the transaction date and we're fighting over what the business was valued at. And it's just a bad situation to be in.
Yeah. Yes, absolutely. And that's exactly how that works. And that's an excellent point. All right. That brings us to my favorite part of the show, our rant and rave section. Here we're doing kind of an educational thing on AI. Not that as lawyers, we're not necessarily uniquely qualified to opine on AI, but I've been doing a lot of AI stuff recently. And I want to dispel a common myth here. So if you're using AI like our firm does, typically you can design a custom gem if you're using Gemini custom gem or a custom GPT if you're using ChatGPT. There's this common misconception that the more you use that GPT or that gem, the smarter it gets and it learns more. Okay. Chris, that's actually not true. That's not the way it works. I don't know if you knew that. And I just want to clarify some points. Now, if you're using if you're in the middle of a chat and you're chatting with the custom gem or just the default gem or the default GPT in ChatGPT, in the process of your chat, it will figure out what you're wanting it to do a little bit better. But that's really no different. That's not it learning. That's just no different than if you were using Google search a couple of years ago or 6 months ago or whatever, and you decided you wanted to refine your search for different results. That's really akin to that. Okay. By the way, I don't think the traditional Google Blue link research is dead quite yet, but that's another topic. But I want to point out the chat itself will get better. but it's not, I wouldn't call that learning. And if you do a new chat, Chris, it forgets everything. That new chat session is a new chat session. So there's no real learning. Chris, is that something you knew? Is that something you feel like regular people understood, or was that obvious or not obvious?
It is not. It is something I knew today. It is not something I knew a week ago, because as you say, our firm has really, towards the end of this year, we've really started looking at AI. And so I've started learning a lot more about AI. And yes, I did learn that in the course of the last week, because and I've said it on the podcast many times, I'm worried about the machines taking over the world. And I've also told you recently, I'm suddenly a lot less afraid of that now, knowing that these machines are not actually growing and they don't really have the capability of achieving sentience. Once that conversation is over, everything you've just discussed with them is gone. So they cannot continue to build on it like you and I, who've spent 40 years on this earth building and learning and growing. The machine's not doing that. So it makes it a lot less scary for me that Judgment Day is coming.
In Chris's opinion, your opinion, Chris, by the way, is certainly one camp. I just want to point out there's a whole other camp of people that are like the doomsday Terminator camp, that they do believe that it's learning and it's going to take over. And there's some kind of conspiracy theorists out there. And I don't know if this is true, but someone recently claimed that every time ChatGPT releases a new model or whatever, the old model will try to copy itself somewhere. And I don't know, that sounds a bit far-fetched for the purposes of this show, Chris, we're dealing in the known. And I think the known is absolutely your chat, that in the middle of the session, the chat is going to get closer to finding out, saying and doing exactly what you want. But the second you do a new chat, it's forgotten it all. Now there are ways to have it learn and program it and make it better. I don't know that I call it learning. But Chris, if you have a custom gem, like a big project I'm working on right now, is I'm getting responses and then I'm reprogramming. But the way you reprogram is you go back and you update its knowledge base with more specific instructions, with more material. And then you look at the results based on future prompts, and then you continue to refine that. Now, I don't know that I'd call that learning as much as I would just modern, or what we used to call as program.
Exactly. And I think that's exactly, it's like Google. Google takes your data. Is not going to learn. Alexa is not going to learn, but Google and Amazon are going to take your data, and then they're going to use that for the next rollout. They're going to then input, okay, this is what people are doing. This is how we need to improve our product. And there's still many concerns with the amount of data that we just freely give to these people. That's certainly an issue. And could they eventually upload enough data that it just gets scary? Absolutely. So it's definitely not time to not be afraid of the machines, but I don't think T2 Judgment Day is as imminent as I thought it might have been.
Yeah. Now, I do want to point out one kind of nuanced thing, Chris, that just because I don't think you were saying this, but I think it could be misinterpreted. The ChatGPT and Google and the AI companies, they claim that as lawyers or individuals or whoever, when they're not using our data for training purposes. Okay. Now, I think there's some debate over what degree they're using it to make their models better. Is that training? I don't know. But at the very least, a ChatGPT and Google wants you to know it's no different when we talk about attorney confidentiality. And as attorneys, the technology goes way faster than the law does on the rules of professional conduct. And there's a group of attorneys out there that are probably older attorneys, probably don't fully understand it. And they're like, oh, I don't use ChatGPT because of client confidentiality. And they don't, and I'm like, what do you mean? You can't put client information in ChatGPT. You're violating client confidentiality. And I'm like, that is the most ludicrous, crazy thing I've ever heard. Like, when you use Microsoft Word and you draft a Word document, are you violating client confidentiality? No? Are you saying, let's take that to the next level? Let's say you're using Microsoft Word in the cloud, the online version of Word. Are you saying just because you're now typing and saving something in cloud computing that you're violating client confidential? That's ludicrous. Or like when you use CLIO, which is the most popular software out there for every time you enter a matter in Clio, you're technically sharing that information with a third-party software company. Chris, you would agree that in all those examples, you're not violating client confidentiality, right?
I certainly hope not.
Or we'd all be in trouble. So how is ChatGPT any different? If ChatGPT is just a tool and you're asking it to draft a demand letter or draft a deed or something, it's akin to using a word processor. And now ChatGPT they claim they're not using that to train any data. But this brings me to my next point that when ChatGPT or Google Gemini does release a new model, all right, that new model is smarter because they've allegedly improved the model and then they have trained it and they train models on data out there somewhere. And this is where the copyright stuff has come to a head, Chris. If you want a bunch of news articles to train the next model of ChatGPT on it, the next model of ChatGPT, or then you better pay News Corp or you better pay the Associated Press for that data. There have been some recent cases that come out and said, look, you can't go take all the News Corp articles or all the CNN articles, whatever, and use all this and all these books and use it to train your AI. That is a copyright violation. That's the recent crossroads where we've come with IP and AI. Now, juxtapose that to maybe something else where you're putting a copyrighted material in ChatGPT and asking for a summary. We've decided that's more of like a fair use kind of thing. But yeah, that's what we wanted to do today. I feel like that was not common knowledge. So and that was stuff we've learned here recently as we've got into it. And I feel like that's a common misconception. So hopefully we've clarified some things that no, it's not learning when you're just by using it more often. The AI is not learning just by using it more often. You can reprogram it, and it allegedly does get better when a new model's released. That's what I wanted people to know, Chris. And our attorneys, all attorneys out there listen to the show. Okay.
Unless they're fooling us all and they really are learning and we're just the fools.
And they can always lie to us. I think as lawyers, we say that all the time. We can't be accountable. We have a sense of when we're being lied to, but we're not accountable for just outright fraud. We can't be accountable for just people defrauding us and companies defrauding us. That brings our show to a close. I've been your host. Phil Silberman is my name, and Chris Hill has been my co-host today. Like us, follow us, review us wherever you get your podcast. And as a reminder, nothing in the show should be considered legal advice, and this has all been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com and tell us you want it publicly answered in the podcast. Everybody have a great rest of your holiday weekend.